The ICC is now adjourned. It's now in session, sorry.
Good morning, everyone. My name is Evelyne Asaala. I'm the president of the bench. With me are two other colleagues, and I would like them to introduce themselves.
Thank you very much, Madam President. My name is Maria O'Leary, and I wish you all greetings today.
Thanks, Madam President. My name is Judge Dalila Seoane, and well, happy to hear the arguments of the council this afternoon.
We now turn to the prosecution. Could you please introduce yourself and tell us your role and time allocation?
May it please the honorable the prosecutor. It shall be my endeavor to establish two things in the next 15 minutes. One, the case against Mr. Gravus is admissible pursuant to Article 17 of the Rome Statute. And two, the court has jurisdiction of this case pursuant to Article 19 of the Rome Statute. This shall be followed by my co-counsel, Ms. Maitri Murali, who will be taking 10 minutes to establish that Mr. Gravus should be held criminally responsible under Article 28. We reserve 5 minutes for rebuttal, Your Honor.
Thank you, prosecution. Shall we now get the introduction of the defense team?
My name is Sanders, and I appear with my learned friend, Miss Sakar, for the defence. I see on the chat that we've been allocated other space for Mr. Hollingworth. Mr. Hollingworth was transferred to the prosecution team, so he won't be appearing today. And I'm very sorry, but my audio wasn't working until about 15 seconds ago, so I didn't hear most of the preamble. If someone could please repeat that quickly. So.
Okay, no problem. I'm sure they will also reintroduce themselves as they do their oral submissions. So I now invite the prosecution to start us off with their oral pleadings.
Mr. President and Your Honor, in the catastrophic attacks which were aimed at destroying tax havens, around 286 lost their lives and several others lost their dignity as numerous incidences spanning across months. As a prosecutor, it is my duty to assist this court in putting an end to impunity to the people responsible for these crimes by ensuring their effective prosecution. Your Honors, on this note, I shall begin with the first issue, that is, the present matter is admissible under Article 17 of the Rome Statute. Your Honor, the negative structure of Article 17 implies that a case is generally admissible unless the prerequisites of inadmissibility are fulfilled. I should prove that the present case passes the consideration of complementarity and gravity through my two submissions, that is, A, Hanatun is unwilling and unable to genuinely prosecute the defendant. B, the case is of sufficient gravity. Your Honor, my first argument is that pre-trial chamber's investigation is in compliance with the complementarity principle because Hanatun was unwilling and unable to genuinely carry out investigation. The ICC Appeals Chamber in Prosecutor versus Saif al-Islam Gaddafi judgment on the appeal of Mr. Abdullah al-Sanusi against the decision of PCC1 in paragraph 218 held, shielding the defendant as a determinant of unwillingness. This case, in determining the relevance of due process rights in domestic proceedings, relied on the two prongs of Article 17(2), namely, A, the absence of an intent to bring the defendant to justice, and B, the lack of independence and impartiality. The prosecution submits that the military court's investigations were a short trial instituted not with the intent to bring the defendant to justice, but rather to avoid ICC's fair trials in the matter, and therefore satisfy the three limbs of unwillingness provided under Article 17(2), that is, 1, political objectives and unjustified delay, 2, shielding through formulation of an extrajudicial body, and 3, systemic lack of independent and impartial investigation. First, Mr. President and Your Honors, political objectives and unjustified delay is evident in paragraph 16 and 18 which proved that Hanatun unwillingly instituted investigations after compelling diplomatic and political pressure by the European Union, ICC state parties, and from national and international human rights organizations. Your Honor, the timeline of the case demonstrates how first, the military court was established on 10th December 2021. This was only after the pre-trial chamber issued a warrant of arrest on 15th September 2021. Further, Your Honor, this occurred 3 years after the UNSC resolution of 2022, thereby proving unjustified delay. Turning to the second limb of shielding, Your Honor, the military court was an eyewash to shield the defendant. According to paragraph 6 of the case fact, it is very clear that there were 3 branches of the state. Even then, a military court was set up to conduct the investigation. And Your Honor, this took place despite the nation having a functioning judiciary. Thirdly, Your Honor, there is sufficient evidence to prove a systemic lack of impartiality and independence because, first, both the parties responsible for setting up the military court, and second, the parties being investigated have either held or are holding influential positions in the military. Second, Office of the Prosecutor's policy paper on preliminary examination holds that public statements to the detriment or in favor of the suspect, breach of the presumption of innocence, discriminatory stance of officials or the executive towards personnel involved in the criminal procedure, etc., could very well be indicators of impartiality in the proceedings. Your Honor, according to paragraph 18 of the case fact, high-ranking military officials advocated for the defendant's release even before the investigation was completed. This discriminatory stance is a result of their professional history of 6 years with the defendant, Your Honor. This speaks volumes about the manner in which this investigation is being conducted. Third, as an alternative perspective to this point, if we deny the high-ranking officials' bias towards the defendant, there could be a bias acting against the defendant because General Witt is a political rival of the defendant. Your Honor, in all these cases, the ideals of impartiality and independence stand compromised. Thus, Your Honor, military court's constitution was evidently a rushed response to international pressure. It was neither impartial nor independent, but merely a shield to avoid ICC's fair proceedings in the matter. Hence, pursuant to Article 17.1 and Article 17.2, Hanatun is unwilling to prosecute the defendant.
Excuse me,
Your Honor, moving
Counsel.
on to...
Excuse
Yes,
me,
Your
Counsel.
Honor.
I have a question in relation to this point of the being unwilling or unable, this particular case about the willingness, and also impartiality, because according to the facts of the case, there's a the intention. I mean, in this particular case, there's a house arrest, and the house arrest is until he will be transferred to this court. That would show at some point the willingness of like the investigation of the case. And at the same time, in terms of impartiality, we know that General Hitch, there were some problems among them, some clashes, and why we would think that there's an issue of impartiality if he's under house arrest.
Your Honor, the house arrest has been conducted in a very rushed manner, and there is no information on how the rights of the defendant are being secured. So even if we consider the matter of due process rights of the defendant and fair proceedings, we do not know as to whether he was given legal assistance, how he was kept in house arrest, and what conditions he is in right now. So this house arrest could generally just be in order to control General Hitt's control over the government and seize all his activities. However, the sanctity of investigation lies in transparency with regards to what's the update with him at this present moment. And I contend that because of General Hitt's political rivalry, there is going to be some sort of impartiality involved. And even if we don't consider that, we can observe high-ranking military officials advocating for the defendant. So in either way, the case in the military court is tainted. The prosecution comments, Your Honor. I sent, Your Honor, I move to the next argument.
You may proceed, please.
Your Honor, moving to the inability of Hanatul, Pre-Trial Chamber 1 in Prosecutor versus Saif al-Islam Gaddafi and Abdullah al-Sanusi, decision on the admissibility of the case against Abdullah al-Sanusi. In paragraph 210, accorded an enhanced burden of proof on the state challenging admissibility to show ability to prosecute. The defendant has spoken about the political and economic collapse of Hanatul on record. In these circumstances, there is an even greater burden on the defense to prove availability of an independent judicial system, and that, one, they do not lack domestic legislation to prosecute the defendant on crimes of an international gravity. Two, they have the ability to collect and preserve evidence without tampering it. Three, the defendant was provided legal assistance in the military court. Four, and while the administrator changed in the military court General Hitch, the personnel did not. So the defense should show that the military court is maintaining impartiality during this transition as well. Your Honor, the defense's failure to prove any of these conditions would imply inability of the state of Hanatul, rendering the case admissible pursuant to Article 17(3). Mr. President and Your Honor, my second argument is that the act of genocide perpetrated by Mr. Gravos were of sufficient gravity. Gravity concerns Articles 6 to 8, Ratione Materiae Jurisdiction, and obliges the ICC to select among the most serious crimes. Your Honor, the number of victims quantitative test is met, as this court has previously held cases with only 12 deaths and 50 to 55 injuries to be of sufficient gravity. In our case, although the exact number is unknown, we do know that at least 700 people have either died or suffered grievous injuries. Therefore, the quantitative test is satisfied in the present matter. Your Honor, I shall prove how the four qualitative parameters of spread, nature, manner, and impact given in paragraph 50 of Prosecutor versus Kenyatta in the decision confirming the charges against Kenyatta are proven through my factual submissions on the Ratione Materiae Jurisdiction for genocide in the second issue. With that, Your Honor, I conclude my first issue of admissibility and shall now delve into the second issue, which is that the court exercises Ratione Materiae Jurisdiction over the case. Your Honor, the prosecution submits that the requisite Ratione Materiae Jurisdiction is made out as the crime of genocide under Article 6A and 6C has been committed. I shall prove this in two counts. First, mens rea or specific intent to destroy Castilians is present. And second, actus reus in the direction of eradicating Castilians is also present. Your Honor, turning to the first requirement of specific intent, Castilians are an ethnic group by the definition given by the Trial Chamber 2 in paragraph 98 of ICTR's Prosecutor versus Kaishima. The definition reads, a group which distinguishes itself or a group identified as such by others and the perpetrators, along with cultural and linguistic parameters. Your Honor, Castilians do fulfill this parameter because they were particularly targeted and identified by the perpetrator, and they distinguish themselves as Castilians. Your Honor, the indication of specific intent is rarely overt. Therefore, Trial Chamber 2, in paragraph 93 of the same case, envision a circumstantial evidence threshold, like the physical targeting of the group or their property. Second, the use of derogatory language, the methodical way of planning, and the systematic manner of killing, among others. The defendant has demonstrated specific intent to destroy this group based on their ethnic identity in various instances. First, the defendant is wearing his military uniform, used derogatory language on air. He referred to the Castilians as 9 rats and vowed to Castilians of the family. This was preceded by systemic ostracization of Castilians by reducing federal transfer payments and political representation within 1 month of coming to power. This was to propagate his own Pan-Hanu nationalist ideas, Your Honor. Second, the order of the counter-terrorism campaign meets the systematic state policy threshold, Your Honor. Paragraph 11 of the case fact demonstrates how the campaign bestowed unfettered powers to the SPG and NDS. It deployed highly aggressive language, such as wanting to destroy CNS terrorists and their Castilian supporters, and further eliminate destructive social factions. Your Honor, this proves that the defendant did not merely intended to find a temporary solution to Caesareans, but wanted to permanently eradicate them from society in the pretext of national security. Third, according to paragraph 13 of the Case Act, a local of Caesarea, who the state deemed as a Caesarean, was forced to say that he was a member of the CNF or he supported CNF. However, Your Honor, he was released only upon discovering his Han ethnicity. Your Honor, the same paragraph mentions Mr. Bryan openly stating that the forces were acting under the orders of Mr. Gravos, and no correction or clarification to this statement followed. This confirms its veracity. With this, I have established the defendant's systematic discriminatory conduct targeting the very same group Caesareans. Thus, Your Honor, the requirement of mens rea or specific intent stands satisfied. Your Honor, my second count is that the requirement of actus reus is also met. The prosecution submits that genocidal killing under Article 6A means causing the death of another person and causing the death of one member of a protected group, such as Caesareans, suffices. This was held in ICTR Appeal Chamber in paragraph 9 of Prosecutor versus Silvestre Gambuzzi. Your Honor, according to paragraph 12 of the case fact, 200 Caesareans were shot dead. Out of this, only 2 were CNF members, in whose garb the government was actually running the campaign. Your Honor, moving on to genocidal conditions of life under Article 6C, the ICTR trial chamber in paragraph 505 of Prosecutor versus Asaala held that the expression deliberately inflicting on the group conditions of life should be construed as a method of destruction by which the perpetrator does not immediately kill the members of the group, but which ultimately seek their physical destruction. Your Honor, these conditions include subjecting the group to a subsistence diet and generally creating circumstances that would lead to a slow death, such as lack of proper food, water, shelter, clothing, sanitation. In the present case, all the thresholds are met as the defendant subjected Caesareans to subsistence diet by blocking all routes of trade and food supply. This caused a famine, filling the streets with bodies of dead women and children. Your Honor, the defense may argue that this conduct was a preventive security measure. However, there is no evidence of any measure to protect the so-called civilians of the region either. Resources were indiscriminately blocked without any justification or backup supply, leading to subsistence diet and in the absence of medical supplies, which definitely amounts to conditions of slow death for ultimate destruction. Your Honor, all these acts were committed intentionally to cause substantial harm to the Caesarean population and thus certainly fulfill the requirement of actus reus. With that, Your Honor, I conclude my second issue. I would now invite my co-counsel to take over and address the third issue.
Your Honors, am I audible?
Yes, you are.
Your Honors, as my co-counsel previously established, genocide has been committed and the individual that should be held responsible is Mr. Gravos. Thus, I, Maitri Morley, shall take 10 minutes to establish that Mr. Gravos is criminally responsible for genocide under Article 28A of the statute. I will be addressing this issue in 4 parts. First, there existed a superior subordinate relationship between Mr. Gravos and his security forces. Second, Mr. Gravos had superior authority and control over the forces that committed the crimes. Third, Mr. Gravos had knowledge or could have had knowledge that the forces were committing or were about to commit these crimes. And fourth, the crimes committed had resulted from Mr. Gravos's failure to exercise control and take reasonable measures. Coming to my first submission, Your Honors.
Excuse me, Counsel, I have a question because you had mentioned that Mr. Gravos, that you will present why Mr. Gravos is criminally responsible. But what is the standard of proof of this instance? Because we are before the pretrial chamber.
Yes, Your Honor, that is exactly what I'm coming to. I'm going to prove the 4 requirements under Article 28A that have been satisfied, which will be holding Mr. Gravis criminally responsible.
Yes, but we are not in the trial stage where we attribute like the responsibility, the criminal responsibility to a specific person. We are assessing the situation according to the facts that are presented by the defense. Sorry, but the defense and the prosecution, of course. But we wanted to know what is the standard of proof applicable to this stage.
Your Honor, the standard of proof that is applicable at this stage is deciding whether Mr. Gravis was actually a superior as per previous decisions of the ICC, the ICTR, and the ICTY, and it needs to be proved beyond unreasonable doubt. Reasonable doubt.
Thanks.
Coming to my first submission, Your Honor, there definitely existed a superior subordinate relationship between Mr. Gravis and his security forces. The ICTR trial chamber in the prosecutor versus Lawrence Samanza in paragraph 401 held that a superior subordinate relationship requires a formal hierarchical relationship where a superior is senior to a subordinate. The pretrial chambers in the Jean-Pierre Bemba for confirmation of charges decision in paragraphs 408 to 410 held that the prosecution must prove that the accused was either a military commander, a de jure commander, or a person effectively acting as such, a de facto commander. Your Honor, from paragraphs 6 and 7 of the case facts, we can see that Mr. Gravis had declared himself president of the country, and he was the de jure president and commander-in-chief of the armed forces. Your Honors, this is proof enough that there existed a superior subordinate relationship with Mr. Gravis at the top of the chain of command. My second submission, Your Honor, is that Mr. Gravis had superior authority and control over the forces that committed the crimes. Your Honors, the pretrial chamber in the Jean-Pierre Bemba Gombo case in its confirmation of charges decision and paragraph 414 held that effective control is a manifestation of a superior subordinate relationship between the suspect and the subordinates. The ICTY appeals chamber in paragraph 197 of the Celebici appeal judgment held that a court may presume the possession of de jure power prima facie results in effective control, unless contrary proof is produced. Your Honors, the ICTY trial chamber in the prosecutor versus Radovan Karadzic held in paragraphs 580 to 583 that effective authority and control is the material ability to prevent or punish the commission of offenses or to submit the matter to the competent authorities for investigation and prosecution. Your Honor, the power to issue orders is indicative of the existence of effective control. Thus, Your Honors, there are 2 requirements to be fulfilled under this submission. First, the existence of a superior subordinate relationship, which I proved in my previous submission, and second, the existence of effective control by the superior. For the second requirement, Your Honors, I would like to draw your attention to paragraph 11 of the case facts, where Mr. Gravis's counter-terrorism campaign is introduced. In clause B, Mr. Gravis has stated that the NDS and the SPG will operate under the direct command of Mr. Gravis and shall have the duty to eliminate destructive social factions. The fact that Mr. Gravis had effective control over the actions of the security forces was only affirmed by Mr. Bryan, the head of the police department, in paragraph 12, where he admits that the NDS and the SPG were following Mr. Gravis's orders while murdering Castilians. Thus, Your Honors, both the requirements under the submission are fulfilled. My third submission, Your Honors, is that Mr. Gravis had knowledge or could have had knowledge that the forces were committing or were about to commit these crimes. Your Honors, the ICTY trial chamber in Cordic and Serkis in paragraph 428 held that the actual knowledge of a military commander will be proved easily, considering the fact that he will be part of an organized structure with established reporting and monitoring systems. The ICTY trial chamber in the Karadzic case in paragraphs 584 to 586 stated that is showing that a superior had general information in his possession which would put him on notice of unlawful acts by his subordinates, is sufficient to prove that he had reason to know. The information does not.
Excuse me, counsel. What is
Yes,
the
Your
legal
Honor.
source for this court to use the jurisprudence of the ICTY according
Your
to the
Honor.
Rome Statute? Yes.
Your Honors, the ICTY and the ICTR are predecessors to the ICC. Their statutes are extremely similar, and thus the court has in multiple instances actually used the decisions or reaffirmed the decisions of the ICTY and the ICTR.
And is there any legal basis in the Rome Statute where we can use for using that precedent?
Your Honor, Article 21, 1, B and C talk about how the court may use its previous decisions, or it may use established principles of in international human rights. Your Honor, there is ample evidence to prove knowledge in our case. I would like to bring your attention to Clause E in paragraph 11 of the case facts, which state that the heads of all 3 security divisions will report to Mr. Gravis. Mr. Gravis was also seen communicating with Mr. Bryan and Ms. Jolie constantly regarding the situation in Castiria. Moreover, from paragraphs 11 and 12, we can see that he in fact allowed his soldiers to murder Castirians. When the entire international community was aware of his soldiers chanting, Castirians are cancer, it is only reasonable to assume that Mr. Gravis definitely had the knowledge. Thus, this proves that Mr. Gravis certainly had the knowledge of the crimes that his forces were committing. My fourth and final submission, Your Honor, is that
Counselor, can I interrupt you? I'm sorry, a bit on that last point of the knowledge available to him. Do we have any direct evidence, or do we need direct evidence showing that he knew about these chants, or that he knew about these statements that were being made?
Your Honor, from paragraph 12 of the case facts, we can see that Mr. Bryan had admitted that 200 Castirians were murdered, and only 2 of them were CNF soldiers, which means 198 people were civilians. And the reason Mr. Bryan had stated was because Mr. Gravis had actually ordered for them to be killed. Moreover, from the other instance in the case, we can see that there were social media images, there were reports of various NGOs, etc., that the entire international community, including EU states, ICC state parties, and other international NGOs were well aware of the situation in Castiria. So this proves that Mr. Gravis might have had an idea that something was happening in his country, and Mr. Gravis failed to take reasonable measures to actually stop that, which will be my fourth submission. Your Honors, my fourth and final submission is that the crimes committed had resulted from Mr. Gravis's failure to take control and exercise reasonable measures. Your Honors, the ICTY trial chamber in the Karadzik case in paragraphs 587. Your Honors, as my time has ended, I request an additional 1.5 minutes to conclude my arguments.
Yes, please.
Your Honors, the ICTY trial chambers in the Karadzik case in paragraphs 587 to 590 held that reasonable measures are those that are reasonably falling within the material powers of the superior. Reasonable measures can include reporting the matter to competent authorities, carrying out an effective investigation to establish the facts, issue specific orders prohibiting or stopping the commission of criminal activities, and taking disciplinary measures against the commission of crimes. Your Honors, in my previous submission, I proved how Mr. Gravis had knowledge of the crimes that his forces were committing. However, Mr. Gravis failed to do anything about this. He, in fact, actively asked his forces to murder Castirians. The ICTR in Prosecutor versus Karamera and Girimpatse held in paragraphs 1564 to 1565 that the only reasonable measure for preventing mass killings by the Kigali Interhamwe would have been to take any step that delivered the message that the Interhamwe should immediately stop murdering Tutsi civilians. However, Girimpatse used vague language that ignored the genocide that was being perpetrated by his subordinates. Here, the court did not accept that Girimpatse took reasonable measures to stop the crimes by his subordinates. In our case, Your Honors, Mr. Gravis did not even take a single measure against his forces, let alone a reasonable one. We can conclude that Mr. Gravis did not exercise proper control or take reasonable measures. I would like to rest my case, Your Honors. I express my fervent hope that justice be rendered to the victims of this crime that has greatly shocked the Republic of Hanaton. Wherefore, in light of the issues raised, arguments advanced, and authorities cited, the prosecution most respectfully requests the Chamber to declare that the case against Mr. Gravis is admissible pursuant to Article 17. The case falls within the jurisdiction of the court pursuant to Article 19, and that there exists reasonable ground to hold Mr. Gravis criminally responsible for genocide under Article 28A.
Thank you, prosecution. I now invite the defense team. Defense team.
Yes, sorry. May it please the court, the defence makes 3 submissions. First, we submit that the case against Mr. Gravis is inadmissible under sections 17A and 17D of the Rome Statute. Second, we contend that the court does not have jurisdiction in this case, pursuant to Article 19 of the Rome Statute. And finally, we contend that Mr. Gravis is not criminally responsible for the crime of genocide per Article 28A of the Rome Statute. And unless the court has any preliminary questions on this, we will proceed to our first submission. Our first submission contains 2 arguments. First, that the case is inadmissible owing to an ongoing investigation by Hanaton, and second, that it is inadmissible as a result of insufficient gravity. We understand that the burden is on the defence's side, that to prove that there is an ongoing investigation. And this is supported by facts and evidence which would show that, to the court that the prosecution did not even pass the admissibility test to prosecute Mr. Gravis. We submit that there is an ongoing investigation into the case within Hanaton's domestic jurisdiction, which satisfies Article 17(1)A of the statute, and that Hanaton is willing and able genuinely to carry out the investigation. First, Mr. Gravis was arrested and placed under house arrest from the 13th of September 2021, according to paragraph 17 of the case facts, until he was transferred to the court on the 20th of February 2022, paragraph 3 in the case's procedural history. On the 10th of December 2021, a military court was established to investigate the crimes committed in the conflict regions as of the 3rd of November 2015, including Casteria, and this is in paragraph 18 of the case facts. The location and the time frame, which expands the investigation even beyond that of this current case, and thus examine the conduct at hand, including the events in Luce, Lusari, and Casil. The military court has announced it will complete its investigation in August 2022, showing that the investigation is active and ongoing. Second, the defence submits that Hanaton is willing and able genuinely to carry out the investigation under Article 17(2)(c) of the statute, and this investigation is being conducted independently and impartially, and in a manner consistent with bringing the accused to justice. The question of whether a state has the intent to bring a person to justice itself is to be determined on a case-by-case basis, per the Katanga reasons for the oral decision at paragraph 91. This same case established that in order to ascertain the intentions of the state, the level and form of cooperation received by the court from the state regarding a particular case can be indicative. In this instance, Hanaton is providing little to no cooperation with the court and has clarified that it is committed to completing the investigation within its jurisdiction. This is at paragraph 18 of the case facts. This therefore renders the case inadmissible in lines with the aims of complementarity that underline the court's functioning per the preamble of the UN Treaty Series, volume 2187. Statements by military officers presented to the court reveal no evidence to suggest that the military officers who have expressed their doubts about Mr. Gravis's guilt are involved in the investigation or will be involved in any subsequent prosecutions of Mr. Gravis. Indeed, my learned friend for the defence makes a point about impartiality. However, we submit that impartiality requires an element of confidentiality for national security purposes, and it is not the proper role of the court to demand disclosure of potentially sensitive information in an attempt to gain the ability to hear a case when doing so is clearly against Hanaton's wishes. So the lack of information that is forthcoming about precisely who is being prosecuted, we submit, is very much for Hanaton to decide itself, and it's not the place of the court to question its ability to hear the case entirely on this basis. A further reason why this case is inadmissible is owing to the insufficient gravity of the case to justify further action by the court, according to 17D of the statute. This case fails a holistic evaluation of all relevant quantitative and qualitative criteria, including the scale of the charged crimes, the degree of participation of the accused, the degree of intent, and the commission of crimes for discrimination, which are all relevant criteria per the Al-Hassan judgment on appeal, paragraphs 53 and 89 to 90. Regarding the scale of the crimes, the case has only discussed incidents particular to 3 cities with 286 identified victims. This is in paragraphs 12 and 14 of the case facts. The court in the Hassan judgment mentioned above noted the number of victims as a key quantitative factor in assessing a case's gravity. Furthermore, the command responsibility of Mr. Gravas cannot be established, and most notably, Mr. Gravas took appropriate measures to prevent such crimes against civilians from being committed, which we contend is evident in the case facts, Exhibit 1. We will discuss this further in our third submission, unless Your Honours wishes to do so earlier. Mr. Gravas additionally does not... Sorry, was that a question?
I did actually have a question about the number that you've raised, that the number is a factor in the gravity assessment. And I'm not sure if that was part you were getting to later, but I guess I'd have a question as far as what is the defense's position of a sufficient number then for the case, or where would the court find that the gravity line is crossed? How many people need to be victims?
Your Honour is correct. We will be reaching that in our third submission. However, we contend that although we cannot place an exact number, 300 is very much not sufficient and not in keeping with previous cases. For instance, if one looks at very notable cases of genocide, such as the Rwandan genocide or the Holocaust, it's nowhere even in the same order of magnitude. And while we agree with the implicit point in Your Honour's question that it is wrong to create an exact cutoff, an order of magnitude is surely sufficient to say that it is not sufficiently sufficient gravity.
Thank you. In going forward ahead in your submissions later, maybe if you can address this in the context of the registered vessel case at the ICC, the Comoros case as well, and the Chamber's submission or the Chamber's findings on gravity there. Thank you.
Yes, my learned friend, Mr. Carr, will be taking the point about the command theory and jurisdiction, and I'm sure she will be more than able to cover Your Honour's question.
Thank you.
Follow-up question?
Yes.
Supposing we declare this case not admissible, how sure or guaranteed are we that Mr. Gravas will be prosecuted for the crimes that he's being prosecuted before this court?
I'm sorry, I didn't quite hear that. About ensuring that Mr. Gravas is prosecuted, was that, sorry?
Similar crimes, yeah, as those before this court.
I'm really sorry, I can't hear. Would you mind just typing it in the chat box? My internet's not very good.
How sure? What are the indicators that Mr. Gravas will be prosecuted for the same crimes that he's being prosecuted before this court?
Oh, the indicators are that he has been arrested by the government in Casteria, which indicates that he is being prosecuted for something, and that there is an ongoing investigation relating to events for which he was in charge. And taking a natural view of causation in this instance, it becomes apparent that where one is investigating the actions of the state and one has arrested the head of state, we think it is quite fair to draw a causative link between those two.
Yeah, maybe just to make it more clear, are the ongoing investigations over the same crimes before this court, the crime of genocide, for example?
So how do we know that Hanatun is investigating genocide?
Yes, how sure are we that there'll be no impunity if we don't admit this case?
I think, first of all, we have to take it in good faith. And again, we cannot assume that because Hanatun does not wish to comply and provide further information, that means they are not investigating it properly. I think we would have to wait to say that they have definitely not investigated it for genocide in the spirit of good faith. And we would therefore have to wait until the findings of the military tribunal next year. There isn't an expiry date for when someone can be prosecuted for genocide. So I think it would be in the court's interest in terms of their general respect in the international community to wait until we are certain that genocide is not being investigated, as opposed to a suspicion that it is not.
Proceed.
Yes. My speech is mostly finished. Mr. Gravis does not possess specific intent, and any perceived discriminatory marks from Mr. Gravis have been refuted as distortions and further clarified, which we can see from the case facts, paragraph 10. So unless your honours have any further questions, we will now move on to our second submission, which my learned friend, Ms. Sakar, will cover. Thank you.
Thank you. May it please the court, my name is Ms. Sarkar and I will address the court on jurisdictional issues pertinent to this case. The defence concedes that jurisdiction ratione temporis, loci, and materiae are established on the facts, pursuant to UNSC Resolution 2022 under Article 13b of the Rome Statute. However, it is submitted that jurisdiction ratione materiae is not satisfied, and the court hence does not have jurisdiction to prosecute Mr. Gravis. Turning to my first submission, Mr. Gravis must have acted with dolus specialis, requiring the intent to destroy in whole or in part the targeted group, pursuant to the Bashir first decision for arrest warrant, following the inferential methodology outlined in the Judicial appeal at paragraph 48. Firstly, the framework for analysing dolus specialis is more stringent than the prosecution appears to rely upon. Despite rejecting the only reasonable conclusion analysis outlined in al-Bashir, the appeals chamber decision against the arrest warrant in al-Bashir did not default into stating that any reasonable inference would satisfy the dolus specialis. Rather, paragraphs 29, 30, and 33 are expressly limited to stating that the only reasonable conclusion standard, specifically, is incompatible with the reasonable grounds to believe threshold set out in Article 58(1)(a) of the statute. Broader methodological jurisprudence beyond this rejection is hence apposite, such as the requirement in paragraph 524 of the Appeals Chamber judgment in Nahimana et al. That such reasonable inferences be drawn from the totality of the evidence. The prosecution hence may not cherry-pick which incidents and events they apply the Judicial inferential methodology when seeking to fulfill 58(1)(a). On this basis, it is submitted that the dolus specialis cannot be reasonably inferred from Mr. Gravis's statements. His statement on the 16th of March 2019, vowing to eradicate this Casterian cancer, can reasonably be understood as referring only to those Casterians who are cancerous. He is referring to a subset of Casterians, as confirmed by Mr. Gravis's spokesperson to be CNF members who are cancerous. Indeed, this interpretation is supported by the CNF's own use of Casterian. As stated in the case facts paragraph 7, the CNF included other national minority groups, so it is evident that Casterian in the CNF's name is a symbolic and non-literal piece of wording. It stands as a shorthand reference for the CNF, as it was in Mr. Gravis's speech. Paragraph 82 of the Judicial trial judgment confirms that Mr. Gravis must target at least a substantial part of the group to satisfy the dolus specialis. This was confirmed and extended in the Christic appeal judgment, paragraph 8, to require the overall survival of the group to be potentially undermined by the crime. As Mr. Gravis's statements of eradication apply to the CNF only, a substantial part of the Casterian population cannot be said to have been covered by his statements. Indeed, his very distinction between the CNF and the Casterians undermines the point raised by the Christic appeal judgment. Can Casterian survival really be undermined if individuals can merely choose not to support the CNF? Furthermore, Mr. Gravis's May 2019 statement for security forces to take any and all necessary means to destroy CNF terrorists and their Casterian supporters statement rests upon an assumption that CNF terrorists and Casterians are distinct groups and demonstrates that the only Casterians whom Mr. Gravis's intention to destroy pertains to are those politically affiliated with the CNF. There is hence no reasonable basis on which to infer that the dolus specialis from Mr. Gravis's speech. Sorry
for the interruption. How would you justify killing 200 people just to find out that only 2 of them were affiliated to CNF?
Yes, so I do think that that was a very unfortunate tragedy that occurred. However, it is not clear on the case facts whether or not these people gave belief for them to be affiliated with the CNF, because whilst in reality only two have these concrete links, there may be many who are actually influenced by them, who could have these links that are a lot more subtle, and therefore it was almost necessary to ensure that these terrorist groups, as Mr. Gravis labels them, do not have the means to continue. Because whilst it may have only been two that were affiliated with them on this occasion, should there be another instant in future where they were more picky in a way about who is actually targeted, there may be more of them who get away with this crime. I hope that this satisfies Your Honour's question, and I will then move to my second submission. Thank you. Turning to my second submission, it is submitted that neither of the common elements pursuant to Article 6 of the ICC Elements of Crime are fulfilled. Firstly, and with regard to objective factors pursuant to the Akiyesu trial judgment, Castilians do not form an ethnic group under the 1948 Genocide Convention. In paragraph 137 of the Bashir first decision for arrest warrant, the finding of distinct ethnicity was phrased both conjunctively and with exclusive possessory language. The groups therein had its own language, its own tribal customs, and its own traditional links to its lands. Castilians' links to the Castilian province are neither traditional nor their own. Their 1889 relocation was forced, and their current presence is motivated by a profitable business of mineral extraction. In addition to this, there are other ethnic and religious groups present in the Castilian province. Therefore, the land is neither their own nor traditionally so. Regarding the context of a manifest pattern of a similar conduct, the conduct of the NDS, SPG, and police lack the scale of attack and operational coherence of groups in cases where this condition was satisfied. In paragraphs 15 and 16 of the Bashir second decision for arrest warrant, the effect of an attack on hundreds and thousands of individuals alongside the attack occurring for well over 5 years permitted this condition to be satisfied. This contrasts the mere potential hundreds of victims in this case and the 4-month time frame. Additionally, operational requirements are suggested by footnote 29 of this decision, which speaks of attackers encircling targeted villages, transferring vast amounts of resources, and preceding their attacks by aerial bombings by planes. Furthermore, paragraph 770 of the Tomelea trial judgment speaks of vast transfer of military personnel alongside an effort to conceal what had occurred. In this case, there was no attempt to conceal, and it wasn't sufficiently systematic in terms of the preliminary behavior. Finally, regarding specific material elements and genocide by killing, the defense submits that this element is not sufficiently met, as it remains unidentified which individuals shot the 200 men in Luz and Lazari on the 15th of July 2019, and the 86 men between July and October 2019 at checkpoints. In addition to this, the head of the Hanatoon Police Department rejected the International Human Rights Defenders claims. There is no information providing reason to believe that these killings were conducted by persons for whom Mr. Gravis maintained responsibility. Secondly, Mr. Gravis did not deliberately inflict conditions pursuant to the ICC Elements of Crime Article 6D, which were objectively probable to bring about the physical destruction of the Castilians pursuant to paragraph 742 of the Tomelea trial judgment. Firstly, in paragraph 908, footnote 2263 of the Presiding trial judgment, the trial chamber found insufficient evidence for conditions wherein detention lasted 4.5 months, and detainees had access to food twice daily, since this did not permit the inference of being calculated to bring about physical destruction, which was expressly stated in footnote 2264 in an analogous context. The Krajnik trial judgment at paragraph 863 states this more generally, that this inference is not permitted wherein conditions, albeit inadequate by any number of standards, may be adequate for the survival of the group. The establishment of checkpoints in times of military campaigns is a standard practice, and Mr. Gravis at no time expressed that humanitarian aid cannot or should not be delivered.
Excuse me, counsel. I have a question in relation to what you were mentioning about infliction of condition of life. the elements of the crime, the footnote number 4, refers to deprivation of specific aspects, deliberate deprivation of resources indispensable for survival. And these include foods and other medical services. So why this wouldn't be one of the cases, given that the element of the crime seems to be that through the fact of the having blocked the route, this could be maybe one of the consequences because they didn't have enough resources to survive.
Yes, thank you for your point, Your Honor, and I take the sentiment of it. However, I do believe in this situation that the establishment of the checkpoint was not an explicit attempt to limit the survival of this group. It was more about security, ensuring that terrorist attacks aren't continuing, which was Mr. Gravis's intention. And as previously mentioned, it is a common practice that is quite established, and there was no express forbidding of this aid being delivered. So whilst it may not have been delivered and whilst it may have been more difficult to do so, it was not an explicit attempt to prevent it, if that makes sense. And therefore, I do not believe that, so the defense does not believe that this condition was satisfied.
Thanks.
Can I ask a follow-up question to that, though? If we look at paragraph 16 of the facts, it indicates that the stoppage or this order of having these blockades, then of course, as my fellow judge has said, created a widespread famine. And the next part that we're looking at here is that is what caused the UN Security Council to adopt a resolution and actually invite investigations because of the widespread famine. Does the widespread nature of that in the UN resolution not point to Mr. Gravis then being able to link those facts? Shouldn't he have known from that was there's a causal link there between the blockades and the famine?
Yeah, so I thank you for your point, Your Honor. I think one of the main arguments of the defense, actually, when talking about this, is that there was not a targeted group that can be identifiable. So the conditions of life were not calculated to bring about physical destruction of the Castirians in whole or in part. And this was because, given the fact there were multiple groups living in Castiria, as well as the lack of identification of victims on the streets of Luz and Sizzle, which was allegedly connected to a lack of food, the prosecution cannot show an objective probability of these conditions leading to the physical destruction of a group in part, because it was a widespread destruction, as you said, that prompted the UN to adopt such a resolution, but it was not necessarily pertaining to Castirians, and therefore it cannot be termed as a genocide. I hope that this answers the question, Your Honor, and I will then move on to my third submission.
Yes, please.
Okay, thank you. Your Honor, I will now argue for the defense on the third submission that Mr. Gravis should not be convicted of genocide and war crimes, as he cannot be held accountable as the four criterion of Article 28 of the Rome Statute are not satisfied on the facts beyond a reasonable doubt. Firstly, Mr. Gravis was not effectively acting as a military commander over forces who committed the crimes. Regarding the crime of genocide of killing and genocide by deliberate infliction of conditions of life calculated to bring about physical destruction, it remains unidentified which individuals shot 200 men in Luz and Lazari on the 15th of July 2019, and the 86 men between July and October 2019 at checkpoints mentioned in paragraphs 12 and 14 of the case facts, a fact which is refuted by the head of the Hanjin Police Department, as explicitly stated in paragraph 40 of the case facts. The police department, even if implicated in any criminal activity, was not part of the security forces listed in Mr. Gravis's May 2019 order, but rather was instructed to provide logistical support to security forces and was listed as a division. The setting up of checkpoints is outside of the scope of logistical support to forces previously recognized by the court in the Prosecutor and Jean-Pierre Bemba trial judgment at paragraphs 412 to 18. The contentious element regarding the establishment of Mr. Gravis acting as a military commander is his purported effective authority and control as a required linked factor, according to the Bemba trial judgment at paragraph 178. The defense submits that Mr. Gravis did not have effective command and control or effective authority and control over the forces who committed the crimes. Effective control requires that the commander have the material ability to prevent or repress the commission of the crimes or to submit the matter to the competent authorities at the relevant time, according to a fact-specific analysis as stated at paragraphs 183 to 185 of Bemba. Mr. Gravis did not have effective command and control of the NDS, SPG, or the police. The court has already considered indicative criteria of effective control, several of which do not apply in this instance, as mentioned at paragraph 188 of the Bemba judgment. Sorry, in advance, is it all right if I request the court for an additional 2 minutes, please, to conclude this submission?
No problem.
Perfect, thank you. Mr. Gravis did not have explicit de jure power of commander, as he declared himself commander-in-chief. He also did not have de facto control, as he was unable to ensure compliance, as evidenced by his communication with Miss Jolie, head of the NDS, at Exhibit 1. In this text message exchange, Mr. Gravis specifically asked about the civilians in Casteria. Miss Jolie ensured that soldiers released civilians arrested by mistake, and Mr. Gravis asked for further reporting of security issues. If the NDS were engaged in criminal conduct against civilians, Mr. Gravis's orders were not being followed, as suggested by paragraph 190 of the Bemba appeal judgment. Moreover, the wording of Mr. Gravis's May 2019 order, allowing all necessary measures for security forces without any other specific requirements from Mr. Gravis, aside from reporting, Mr. Gravis only received one report. Secondly, it is submitted that Mr. Gravis did not have actual knowledge that the forces were committing crimes. Actual knowledge on the part of the commander may be established either by direct or indirect evidence, as said in Bemba appeal judgment at paragraph 191. There are insufficient relevant factors that are recognized by the court establishing Mr. Gravis's actual knowledge that his forces were committing genocide. As previously submitted, the element of specific intent for the alleged genocide is not met. Mr. Gravis had no actual knowledge in regarding to the elements of the crimes that were perpetrated by the NDS and the SPG as required. This is paragraph 100.
Excuse me, counsel. You mentioned that Mr. Gravis only received one report, which is a text message from Jolie. I'm wondering if that is enough for a commander of a military force to receive reports only in text message form, like in a very succinct way. So I'm wondering whether there's maybe the obligation for him as a commander to request more information about the situation on the ground if we compare with the situation that was communicated by some NGOs in the field, on the ground, that mentioned that their crimes were committed.
Yes, so I take your point, Your Honor. However, I do think that in this case, so I do think the text message exchange does constitute a report because the intention was to convey the situation. However, I think if we look at the tone of it, where Miss Jolie says, "Sure, sir," in response to Mr. Gravis's request for updates on security threats and Miss Jolie's coordination with the SPG, means that he took reasonable steps to stay informed and to prevent any atrocities from happening. So it is not his fault that Miss Jolie did not communicate what was going on, because he did very much convey this intention to be kept informed, and this was not honored. I hope that this answers your question satisfactorily. Okay, I think that concludes my time. I hope that the defense has put forward a convincing case for Mr. Gravis to be acquitted. And I will now hand back to the court. Thank you very much.
Thank you very much, defense team. I now invite the prosecution for rebuttals.
Is the counsel audible?
Yes.
May it please this court. Ms. President and your honors, the prosecution would like to present the following 5 points in the rebuttals and show as to why the defense challenge must fail. Firstly, the defense has failed to fulfill their burden of proof that concrete, tangible, and progressive steps were taken in furtherance of the domestic investigations. The defense contended that they want to secure their confidential information. However, Your Honors, the prosecution submits that this is not the standard of proof required. The standard of proof required is to show that investigative steps were taken to collect evidence. This can be in the form of interviews being conducted and also in the form of the state showing witness protection schemes, both of which the defense has failed to show. And this, Your Honors, becomes particularly important given the fact the military court was set up in the previous year and it's going to finish its investigations in August 2022, which is only about a month from the present pre-trial chamber hearings. Your Honors, even at this fag end of its proceedings, the state has failed to show that any investigative steps or collection of evidence has been taken place, let alone show any concrete evidence. Thus, the prosecution reiterates that the domestic proceedings are nothing but sham proceedings initiated solely to shield Mr. Gravis in face of international pressure. Secondly, Your Honors, the defense contended, and I quote, that Mr. Gravis is being prosecuted surely for something, unquote. This, Your Honors, not only shows the lackadaisical attitude of the state towards these proceedings, but also shows the vague and ambiguous mandate of the military court. The military court has not named a suspect, and neither have they mentioned any crimes or charges that they are investigating and carrying out the current proceedings with. Thirdly, Your Honors, the prosecution cannot reconcile the conflicting submissions of the defense. On one hand, the defense states that there was no targeting of the civilians, while on the other hand, there is specific factual basis under para 14, which clearly states that unarmed families and civilians who were only trying to flee the province of Castilla, a province marred by violence and death, those unarmed civilians were shot dead without any provocation by the security forces. Fourthly, Your Honors, the prosecution rebuts the claim that there was no targeting of a specific ethnic group. Your Honors, ethnicity or ethnic group can also be seen by how the group themselves view them, or secondly, can be seen how the perpetrator of the crimes views that particular group. In the present case, Mr. Gravis, a Pan-Hanu nationalist, having Pan-Hanu ideals for his country, having stopped federal payments to the entire region of Castilla, and also not giving any representation to Castilians, in addition to imposing blockades in an already famine-prone region, just go on to show that the perpetrator, Mr. Gravis, in his mind, had clearly logged his target, that is the Castilian ethnic group. Coming to the fifth rebuttal, Your Honors, the defense stated that Mr. Gravis was not the one who shot the civilians. Your Honors, the prosecution submits that Mr. Gravis had the effective control to issue orders that could mobilize all three security forces in the Republic of Hanafi. Further, it was Mr. Bryan, the head of police, who reiterated that they were only following the orders given by the superior, Mr. Gravis. Lastly, Your Honors, the prosecution at the pre-trial chamber stage under Article 61 of the Rome Statute needs to only establish that there are sufficient grounds to believe that the crimes were committed. And the burden at this stage is not that of reasonable inference, only reasonable inference. Your Honors, the undisputed fact in this case is that there were killings of Castilian men, women, and children, and not by an abstract entity, but by specific government actions and by a man, Mr. Gravis. And in light of the submissions made and the facts presented, the prosecution seeks that the court moves ahead with the present case and puts an end to impunity. If the counsel may be of no further assistance to the court, the prosecution would like to conclude its rebuttals.
Thank you, prosecution. I now invite the defense team for some rebuttals.
Thank you, Your Honour. In response to my learned friend's speech, I wish to make a few points. First, my learned friend mentions about there were no concrete steps taken. However, we question whether there is, in fact, anything more concrete than actually arresting the head of state. Even though there is an element of confidentiality that is required, it seems like there is a very clear, concrete step that is being taken. And in the spirit of good faith, we should view this as a concrete step taken. Second, the point that Mr. Gravis didn't shoot the civilians but had effective control to make orders which would prevent it. We think that Mr. Gravis did not have to take each and every possible measure at his disposal, and he may choose the disruptive measure depending on the operational realities on the ground. Most notably, simply juxtaposing the fact that certain crimes were committed by the subordinates of the commander with a list of measures which the commander could hypothetically have taken does not, in and of itself, show that the commander acted unreasonably at the time. Mr. Gravis was remote in terms of geography and had limited ways of preventing or repressing the commission of crimes by the NDS and SPG in reality. Additionally, the measures taken are proportionate to the number of crimes, which in the case of Mr. Gravis is low. Mr. Gravis required regular reporting from security forces regarding the May 2019 order, and further checking in on the treatment of civilians in Casteria are sufficient to show that he took all necessary and reasonable measures as a reasonably diligent commander, which is the requirement under the member appeal, in circumstances at the time over an approximate 4-month timeframe. We therefore urge the court to acquit Mr. Gravis, as it cannot be established beyond reasonable doubt that he is guilty of the crime of genocide. Indeed, genocide, the label of genocide should be saved for only the most severe cases. It's unjust to apply such a label given the lack of proof over the jurisdiction, the admissibility, and the command, especially given the low proportion of victims, less than 300 out of a population of 43 million. Indeed, in the Serbian genocide case, in which 8,000 were killed, the proportion was deemed particularly prescient, and this proportion is not satisfied in this current case. So we urge the court to acquit Mr. Gravis. Thank you.
Thank you very much, defense. The court will now adjourn and we will be back in a few minutes. Good. So we are all here, and we have finished our deliberations, and I just want to begin by thanking both teams. Really, this was a great competition. Both of you put in a great effort, exciting arguments, and we are grateful that, as the competition is getting closer and closer, each team seems to be improving quite much. So congratulations to both the prosecution and the defense team. And at this point, I would like to invite my two colleagues. They will give the comments and feedback, and they will come in at the end to announce the winning team. So welcome, Dalila and Marie.
Thanks, Evelyne. Well, first of all, as my colleague was mentioning, congratulations. You have been, we know the effort that you have been doing for being here. And of course, like this is a new round, more effort, more arguments, more facts, and we enjoyed the session, all the arguments and all the facts and legal arguments that were made here. I will try to focus on some small suggestions for next rounds, of course, not on the substantive aspects, but try to have in mind this for the future. We know that we were an active bench, so relax, because we know that we had some questions, and the idea was to see you in action, because sometimes we know that you have a speech, but this is important, yes, to interact with the judges. So one of the main things that are important is that as you can have an active bench as us, it's important to have in your speech the legal sources of what you are quoting, no? And what is the relevance of a specific arguments and presence. So that's something that would be interesting for including, because some of you have quoted like paragraph, of course, but in general, that's something that you could include. Also, it's important, and of course, we know that this is an online competition, but it's important that you try to be spontaneous with the bench and not to read all the time. I mean, of course, when we are in court, we have notes, we have a structure, and it's fine, but not to read all the time, because you can lose the spontaneity that you need with the bench to start interacting. So with the eye, I mean, of course, it's quite difficult to have eye contact with the camera, but we can see the difference when you are reading and your eyes move. So that's something that is quite important. Another thing that is relevant for next sessions is to have in consideration what is, the specific preceding instant that we are talking about. So try to see this, because it's an important aspect to include in the arguments in general. Then the last point that I wanted to add is that when you have, for example, or when you mention that the colleague will take a specific point in the future or other aspect that maybe were not specifically related to the point of agenda of your speech, try to be sure that your colleague will take that point, because I find it that is interesting to have that interaction among the teams. So in general, that's something that I would suggest. Only one comment for the first speaker of the prosecution. I would revise the device that you were using, because we understood what you said, but there was sometimes in your speech there was a bit of saturation, so we had to do a bit of an effort to understand well what you were saying. We didn't lose, of course, what you said, but I think that could be an improvement for other rounds. So that is on my side. Again, congratulations, and it was a pleasure to be here.
Thanks. I'm just going to pick up from that and make a couple more comments. But first, exhale. You did it. You not only made it to this round, but through this round. So congratulations on that, because it's we can see that a tremendous amount of effort has gone into this, and each round is difficult. And remember, got to keep breathing through all of it. I can only endorse what has been said by my fellow judge on the point of answering judges' questions in particular. It's good to answer them right away. You can allude to what your fellow speakers will say, but make sure they get to it. And be careful anyway on alluding to what your fellow co-speaker may say, because with too much detail, I would just say generally, because they might not get to it if they have to cut it and run out of time. And now it's an expectation in my mind as a judge that this is going to happen. So in managing my expectations, I think, make sure that if you are alluding to what's to come, that it does get there. So you can always cut out the allusion as well. I will just also say, using time wisely in the rebuttal and the rejoinder too, those are responsive. So be responsive as possible. And make sure that you're only addressing, those new facts that need to come up, and be really snappy and sharp with what it is. It's not just necessarily, rehashing points. Make sure that you're really specific in what it is that you're coming back to. And which leads me to my final point on, don't forget the advocacy on this. And I think this is where, when we talk about reading it, things do get a little bit lost. Of course, always you'll know that, and have notes, of course, because you need to know what to cut and how to move on. But a strong intro, a strong conclusion, and a little feeling behind it. Though I'm, sometimes told, make sure don't become hyperbolic or, dramatic. But do have some conviction in your arguments that we can feel. I know we're through a screen here, but something that we can feel too, that you believe that we believe. Because I think it'll really just level up all of your submissions to really getting through those last rounds as shiny. So thank you so much for your time, and it was a pleasure.
Thank you very much, Judge Marie and Judge Dalila. And now to my final role, to announce the winning team. And our winning team for this session was N119, the prosecution. Congratulations.
Thank you so much.
Thank you.
Thank you so much.
Madam President, I think we announced the speakers, the best speakers as well?
Are we supposed to announce the speakers?
Yes, we're supposed to announce the speakers as well.
So our first best speaker was P2, right? And our second best speaker was D1. Thank you.
Thank you.
Thank you so much.
Thanks all.
Good luck.
The ICC is now adjourned.